in the matter of Williams and another versus London Borough of Hackney.
Local authorities look after a substantial number of children, over 70,000 in March 2017. These fall into two broad categories. The largest group were children who have been removed compulsorily from their homes in order to protect them from harm. This requires a court order. But around 16,500 were accommodated without any court order under Section 20 of the Children Act 1989 as a service provided by the local authority for children in need. This is what used to be known as voluntary care. It is not compulsory and involves no interference with the rights and responsibilities of the parents. This case involves 8 children whose ages ranged from 14 years to 8 months at the relevant time. One of them was caught shoplifting. He complained that he had no money for lunch and that his father had hit him with a belt. The police visited the family home and found it in an unhygienic and dangerous state, unfit for children to live in. They exercised a power which they have under the 1989 Act to take the children into police protection without any court order for a period of up to 72 hours. The children were provided with foster placements by the local council. The parents were arrested and given bail on condition that they did not have unsupervised contact with any of the children. After their release, the parents went to the council offices. There they signed a safeguarding agreement, agreeing that the children would stay in their foster placements for the time being. They also signed consents to medical treatment and to the children being accommodated under Section 20. After the 72 hours of police protection expired, they were told that they could not take the children home. They consulted experienced childcare solicitors who wrote letters explaining that the parents wanted the children back as soon as possible and to work cooperatively with the council to achieve this. The council decided that the children should be returned home as soon as possible, but the bail conditions were not lifted for another 7 weeks, after which the children were returned home. The parents brought proceedings against the council, claiming damages for an unjustified interference with their right to respect for their family life, contrary to Article 8 of the European Convention on Human Rights. The trial judge held that they had not given their informed consent to the children being accommodated under Section 20, as had been held necessary in earlier High Court judgments. Therefore, he held that the separation of the children from their parents had not been in accordance with the law, which is required to avoid a breach of Article 8. He awarded each parent damages of £10,000. The Court of Appeal allowed the council's appeal. They held that Section 20 does not contain a requirement for informed consent, although this is obviously good practice, and in the circumstances, accommodating the children was in accordance with the law. The parents then appealed to this court. In a judgment which I have prepared and with which the other members of the court agree, this court gives general guidance about the meaning and effect of Section 20. We agree with the Court of Appeal that Section 20 does not contain a requirement for informed consent. Indeed, local authorities are required to look after children who have no parents, or whose parents cannot be found, or who lack the capacity to give such consent. However, Section 20 gives local authorities no compulsory powers. Section 20, subsection 7, provides that they cannot accommodate a child if a parent who is willing and able to provide or arrange accommodation for the child objects, no matter how unsuitable the parent or the accommodation. And Section 20, subsection 8, provides that any parent who has parental responsibility for a child may at any time remove the child from accommodation provided by or on behalf of the local authority. This means that a local authority cannot take a child away from a parent who is looking after him unless the parent voluntarily delegates the exercise of her parental responsibility to them. It also means that if, as in this case, a local authority are already looking after a child, the authority cannot refuse to return him if the parent makes an unequivocal request for his return. The question here, therefore, is whether there had been an unequivocal request for the return of these children. We conclude that there had been no such request. The solicitors' letters could not be read in that way. Rather, they were sensibly trying to achieve the return of the children as soon as possible in a collaborative way, rather than making a demand which might have pushed the council into taking court proceedings, which would almost certainly have delayed their return. And they succeeded in that, to the benefit of all concerned. Hence, the continued accommodation of these children was authorised by Section 20 and was therefore in accordance with the law for the purpose of Article 8. So the appeal is dismissed. But we emphasise that parents should be informed of the basis upon which their children are being looked after. And if this is under Section 20, they should be informed of their rights to object under Section 20, subsection 7, and to remove the child under Section 20, subsection 8. A local authority can only keep a child if they bring proceedings to authorise them to do so.